Okay, we're on the record in People versus Jeremy Brokaw. This is file number 256796. The record should reflect that Mr. Brokaw is present here in the courtroom today. If I could have counsel put your appearances on.
Good morning, Your Honor. The record, Michael, on behalf of People.
Thank you, Your Honor. Richard Truescreen on behalf of Mr. Brokaw.
Thank you. This is the date and time set for a sentencing hearing in this matter. Mr. Brokaw, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, Your Honor.
Mr. Trush, are there any additions, deletions, or corrections to that report?
There are, Your Honor, just a couple of them. So first, and probably the most obvious, is this is a case I inherited from Mr. Baber after the PSI was prepared. So it lists Mr. Baber as attorney of record, obviously. That's now me. So, I mean, everywhere throughout the PSI where Mr. Baber is listed, I just asked it to change to me.
Okay, we'll make those corrections next.
So pre-sentence investigation report, CFJ 145, page 2, indicates 2 days of jail credit. I think by my calculations, there's an additional 10 days. He reports he was arrested on the 20th of the month.
Mr. DeLeo?
I'm sorry, the 10th of the month, which would be the additional 10 days to today's date.
Okay.
$10 days is correct, Your Honor. 10 additional.
Okay, so a total of 12.
Correct.
Okay. Thank you. Mr. Trush?
And then lastly, CFJ 284A, page 3, the criminal justice system, criminal justice section, entry 1 of the adult history indicates that he served 93 days in jail. That jail is actually held in abeyance. He didn't serve any jail on that sentence.
Okay. Mr. Rolla or Mr. DeLeo, any objection to that change?
No, Judge. In fact, that's going to point out the court.
Okay, we'll make that correction, just adding that 93 days in jail was held in abeyance. Okay, any other corrections?
No.
Thank you. Any challenges to the scoring?
No.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, other than what's already been indicated on the record.
And do you have any challenges to the scoring?
No, Judge.
Okay. Anything on behalf of the people for allocation today?
Yes, thank you. As unfortunately indicated in the defendant's most recent PSI, this defendant's received numerous prior breaks and opportunities in the past to deal with controlled substance addiction, including January 22, 2018, 7411 deferral on a possession of analog charge, which by the way is not scored under the guidelines. Far greater concern is when given the opportunity of a delay of sentence on a controlled substance possession methamphetamine charge, that's number 5 of 6 under the adult history in June of 2023. Instead of taking advantage of this opportunity on his second controlled substance conviction, he then commits the instant offense and loses the benefit of his delay of sentence, all the while not reporting as required to his probation agent. Then also indicating positive for controlled substance while on probation on July 15, 2024 and July 23rd, 2024. The people agree with the statements in the PSI indicating that progressive sanctions are warranted in this particular case, and that in addition to some upfront jail time, we would recommend at least 2 years of probation more fully monitored to the defendant's progress, or in this case, perhaps lack thereof, whichever is appropriate. Thank you, Your Honor.
All right, thank you, Mr. Trush.
Thank you, Your Honor. I think the PSI here does a good job of balancing some, I don't want to say abnormal circumstances, but Mr. Brokaw presents for the court without a significant criminal history, which would seem to suggest a jail sanction may not be appropriate. I also think that the PSI does an accurate job of indicating at the time the PSI was created, I think it's accurate that he was minimizing his continued use of controlled substances and really downplaying the issue that he had with it. I don't think it's uncommon for us to see that. And I think looking at the criminal history, you can kind of see the progression. In 2022, he has, or I'm sorry, 2017, he has the first controlled substance offense that he has, which is taken under 7411, and he successfully completes that probation and that charge is dismissed. In 2022, we see another case. He's not able to complete that probation successfully. He violates and ultimately loses the benefit of the bargain he had there, being that delay of sentence. And now we have the current circumstance, which sort of overlaps with the other one. So I think it's fair to say from his record, there appears to be a bigger issue than I think he realized that he had. I do think as he presents here today for the court, the circumstances are a little bit different. I think he recognizes now the significance of the issue that he has. The circumstances that brought him back before the court are significant. How he was sort of apprehended and brought back before the court is he was found unresponsive in his vehicle and was transported to a hospital where he was resuscitated and ultimately then taken back into custody. And he reports to me this is an eye-opening circumstance for him. If someone hadn't intervened and if he hadn't been located there, he may not have survived. So I indicate all that to the court because I think the PSI is accurate and was accurate at the time. I think that he does have more insight into the depth of the issue that he has as he stands before you today. I would suggest to the court that a blended sentence is likely appropriate. I certainly think there does need to be a punishment element to it. I certainly think that some jail is appropriate given the circumstances. I would suggest to the court that considering rehab at some point during that jail sanction is an appropriate step to take. Again, given the lack of history that he has, I think it is a good step to take to have him end the sentence in a treatment setting, to put him in a position to be successful on the probation. And I would suggest that a term of probation is appropriate. Thank you.
Thank you, Mr. Brokaw. Is there anything you wanted to say today?
I just asking, like, I realized that I had a problem. Like, I'm not a bad person. I just got an addiction and I can't do it on my own. I finally realized I need some help.
Okay. I read through the report. I'm familiar with what happened in this particular case, as well as your background and your circumstances from the information in that report. And I take all of that into account along with what the lawyers have had to say here today and yourself. And, I think everybody is kind of in agreement. And I don't think it's a matter of whether you're a good person or not. I think it does come down to a substance abuse problem that you have. And so the question is, what can we do as the court to try and force the issue with you to, at least require you to get some help while you're under our jurisdiction? And then what you do with that is going to be up to you. But I do think the recommendation is appropriate. I think, there are some indicators you were successful on 7411. The delay didn't go as well as Mr. Rolla pointed out, but
Until the end.
yeah, I think there's certainly indications that you can be successful on probation and that hopefully you can use the resources that will be available to you to get help for yourself. I do think some punishment is appropriate as well. You've had some opportunities to kind of correct things before now, and that hasn't happened. So at this point, I think some punishment is appropriate with the opportunity for treatment as part of that. So I think generally the recommendation is well crafted. The court is going to follow it to the extent that I am going to place you on probation for a period of 18 months. You do have, the court's going to adopt as the conditions of the probation, all the terms and conditions that are listed in the report. The court is going to order that you serve 6 months in the Otsego County Jail with credit for 12 days served. The court would allow you to be released to treatment after 90 days. So if you can find a bed at a residential or inpatient treatment facility after that first 90 days, then I would allow you to be released from the jail. If you successfully complete that treatment, any remaining time on that 6 months, the court would hold in abeyance. and you would get credit for the time that you were in treatment. If you didn't successfully complete treatment, you'd be returned to the jail and you have to finish that 6 months. And you wouldn't get credit for the time that you were out during treatment, okay? The court is going to impose a crime victims assessment of $130. Court costs of $325, attorney fees of $350, $68 state cost, and supervision fee of $30 per month while you're on probation. I'm sure Mr. Trush has kind of discussed this with you, but you're starting to amass enough of a record now where your guidelines are going up, and your chances that probation and short jail sentences are running out really quick. So I hope that you take advantage this time of treatment, and that you're able to successfully complete your probation, because otherwise you're starting to get in that area where you may have to go to prison. And I don't think you want to do that. That's not going to be good for you, certainly. So that is the sentence of the court. You do have the ability to seek an appeal of the sentence. Mr. Trush, have you been able to provide those appellate rights to Mr. Brewer?
I did. We went over them. He acknowledged the receipt of them, and I returned that to the court already.
Mr. Rolla, anything else we need to address in this case from your standpoint?
Not from people, thank you.
Mr. Trush?
Does the court want me to prepare the sentence addendum order regarding rehab that we typically do?
Please, yeah, and I've indicated to the jail here that he's eligible for release to treatment after 90 days. Good luck to you going forward, Mr. Brokaw.
Thank you, Your Honor.
We had Mr. O'Neill joining from Waxhaw County. Sir, are you Colby O'Neill?
Yes, sir.
We'll go on the record in file number 246759. This is People versus Colby O'Neill. The record should reflect Mr. O'Neill is appearing today by video from Waxford County. If I could have counsel for your appearances on.
Record, Your Honor, my phone got people.
Thank you, Your Honor. Richard Trush, appearing as duty attorney for Mr. O'Neill.
Okay, and we're here today based on some alleged probation violations. Is that correct, Mr. Trush?
I believe so, Your Honor.
Have you had an opportunity to go through those with Mr. O'Neill?
I have not had any discussion with Mr. O'Neill. I didn't know he was lodged until today.
For some reason, the file, we don't have a copy of the violation.
That seems to be uniform, Judge.
Okay.
Mr. Truce is going over it now.
Okay, do we have a copy that I can use? So, Mr. Trush, you've not had an opportunity to speak with Mr. O'Neill?
I have not.
Okay, did you want an opportunity to do that before we go forward today? I can put you into a breakout room.
I think that would be for the best.
Okay, so Mr. O'Neill, I'm going to give you an opportunity to speak with an attorney here before we go forward with this arraignment. Do you have any objection to that?
No, Your Honor.
Okay, so Mr. Trush is going to sign in onto Zoom, and then I'm going to put you into a breakout room with him so that you can have a private discussion, okay?
Thank you very much.
Okay, Mr. Trush and Mr. O'Neill, I'm gonna put you into that breakout room right now. Okay, everybody's rejoined us now and we're back on the record. Mr. Trush, did you have an adequate opportunity to talk to Mr. O'Neill?
I did. We were able to go over what the allegations are, the difference between technical and non-technical violations, as well as get some information about his current circumstances over in Wexford. At this time, we would waive a reading of the allegations and enter a not guilty plea. He has been screened and approved for appointed counsel. I believe it will be me, but I'm not the one who makes that determination. And then I would indicate for the court, the charges here or the allegations here form the basis of the charges that are holding him in Wexford. He's indicated to me that procedurally they just waived the preliminary exam and he's waiting for his first status conference in circuit court. So with that in mind, having discussed it with them, we would waive the timeline here so that we can allow some things to happen in that case before here.
Okay. Mr. O'Neill, were you able to hear everything that Mr. Trush said there?
Yes, Your Honor.
Are you in agreement with your attorney?
I am in agreement, Your Honor.
Okay, great. Mr. DeLeo, in terms of a bond pending a hearing, whenever we do have that, do you have any recommendations?
He's being held, Your Honor. Now, I don't know what his bond is, but he hasn't posted it clearly, so a PR bond would be fine from the agent's standpoint.
Okay, so the court will, Mr. Trush, you said that you waived the preliminary. I think if we set this for 60 days, does that sound reasonable?
I think it would be, and if something happens that would require us or demand a hearing sooner, I certainly can contact the court. I would suggest to the court, I would ask a small cash bond be put in place as opposed to a PR bond, just because it could affect his credit.
Okay. All right. So number one, the court, Mr. O'Neill, will enter a not guilty plea on your behalf with regard to both the alleged violations in this case. The court will set this for a hearing in about 60 days. The court will impose a bond. The court will note for the record that the 14-day time limit has been waived. The court will impose a bond of $100 cash, along with all standard conditions of bond and all conditions of probation. You'll be notified of the date and time of that hearing, and your appointed counsel, whether that's Mr. Trush or someone else, will be in touch with you prior to that date so that we're ready to proceed. Mr. DeLeo, anything else that we need to address here?
Nothing, Your Honor. Thank you.
Okay. Mr. Trush.
Nothing further.
Mr. O'Neill, did you have any questions at all about how we're going to proceed with your case?
No, Your Honor, I understand completely.
Okay. All right. Thank you. That's all for today. And the court's going to disconnect this time.
Thank you. I love you, baby.
Okay. People versus Jamie McKenzie, file number 256877.
For the record, Your Honor, my fellow application.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. McKenzie.
Right. This is the date and time set for a sentencing hearing in this matter. Mr. McKenzie, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, sir.
And Mr. Trush, are there any additions, deletions, or corrections to that report?
I do have a letter to provide to the court rather than that now.
Yes.
This is a letter from the Lions Den, their, I think, assistant director.
Did you want this attached to the PSI?
Yeah, sure.
I've had a chance to review that letter. Mr. Trush, are there any other additions, deletions, or corrections?
No, you're not.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Judge.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Yes, as people also were just recently shown this morning, the letter from the Lions. As much as we would like to believe that Mr. McKenzie is finally recognizing he has issues and in fact is now wanting to seek some help, the facts are belying that in that these are his 12th and 13th felonies. His outstanding warrants from Kentucky. It's the situation where under the guidelines, he's 12 to 36, so he's looking at incarceration. And back on November 25th of 2004, he received a 207-day sentence on his 9th felony. As the court's well aware, when persons keep repeating the same behavior over and over again, you get past the point of rehabilitation, and you get to the point where there has to be progressive penalties and sanctions. This is such a time. And again, I think that should be dealing with fleeing or looting and resisting and obstructing charges. And Mr. McKenzie not only places himself, officers, but the public in general in risk because of his actions. He should be held accountable for that. Thank you, Judge.
Thank you, Mr. Trush.
Thank you, Your Honor. I have been familiar with Mr. McKenzie basically since I arrived in Otsego County a little more than a decade ago. I've dealt with him and his family a fair amount. When I look at this PSI, I certainly can understand the recommendation that's made here. As we look through the compass narrative, right? What are the areas that are identified as needs for Mr. McKenzie? Leisure and recreation, social isolation, substance abuse, cognitive behavior, family criminality, vocational education, residential instability. All of these are needs that can and are being addressed through the Lion's Den program. I certainly can understand that there's history. The vast majority of Mr. McKenzie's history is nonviolent history. It's property crimes. Frankly, the vast majority of his history, I think, is poverty driven. That's really neither here nor there. I would suggest to the court, I certainly do think that the guidelines require something to be imposed. I think the question the court's going to have to answer here is, how is society better served? Is society better served if Mr. McKenzie is given a MDOC sanction or, I don't know, midpoint of the guidelines is probably what, about 20 months or so? Is that what best serves society here? Or is he better served by continuing the program that's working well for him? Continuing a program that's going to put him in position to not be continuing to repeat the same patterns over and over. I think that the community is better served with him completing the program. And I think a sentence can be crafted in such a way that if he does not complete their program, he doesn't comply and he doesn't change his behavior, he faces that sanction. The low end of the guidelines here is 12 months. If the court were to impose a 12-month jail sanction, hold it in abeyance pending his completion of the Lion's Den program, I think that strikes the right balance, both of punishment and rehabilitation. It punishes the behavior. It takes into account and recognizes that the behavior is inappropriate and dangerous, but it also recognizes that he's in a position to make meaningful changes in his life. He has more support through the Lion's Den than I think he probably has, again, in at least the 10 years that I have been familiar with him. So what I would suggest to the court is I think that better serves the interest of the public than imposing an MDOC sanction, which again, likely has him back in the community, probably without the same benefit of the intervention that Lion's Den is going to give him. Thank you.
All right, thank you. Mr. McKenzie, anything you'd like to say?
Yes, Your Honor. I've had more change in my life in the 3 months that I've been at the den than I have in the 41 years of my life. Growing up, I've never really had direction and guidance and love, and I have received every bit of that from the den. I am out there helping at food drives, but all over the area, whether it be the Michigan Works, the Roscommon County Sheriff's Department. I'm also the automotive equipment manager at the den. I keep all the mission vehicles running and operating correctly. There's so many positive things that's happened in my life and that I'm able to put out towards the community and also within the house that I've never had the opportunity to have before. If I would have had this years ago, if I even would have known about this, been able to implement this program, I guarantee a lot of the things that I did in my past would have never happened. And I just humbly request that that you please allow me to stay in the den and complete the program, because it is an 8 to 10 month program, but I'm also allowed to stay on a staff and help others that were in my situation, that were doing the same things that I used to do, and help them and prevent them from messing up further. And I understand that there is a reason to put a sanction on me, but I just humbly request that you could hold that in advance and allow me just to complete the program. I've already gotten so much just in the 3 months. I only can imagine what I could gain in the 8 months from that, and then to be able to stay on for staff. That's all.
Thank you. I did review the report, so I'm familiar with your circumstances, your background, and your history, which is not good, as you well know. Numerous felonies and misdemeanors. I also reviewed the information in the report about the incident that brings you before the court here today. And I read the letter, obviously. Clearly, it sounds like based on from the Lions Den perspective, you've been doing some good work there, and that certainly warrants consideration. And then, of course, what the lawyers had to say and yourself here, taking all of those things into consideration. There's a couple of things that really stick out to me. Number one is your prior history. You've got a demonstrated long-term history of engaging in criminal activity. And whether it's assaultive or not, what it's driven by doesn't really matter to the people who have to deal with the crimes that you've committed and are victims of that. The crime in this particular case is concerning to me because it does involve public safety. You put yourself in danger, you put the officers in danger, you put members of the general public who, again, if you injure or kill somebody out there engaging in conduct like this, they don't care what your motivations are or what's happened in your life. All they know is they've been severely injured. So that gives me a lot of concern. And while you may have been doing some good work at the Lions Den over the past 3 months, that amount of time is tiny in compared to the amount of time that you've spent doing things that have victimized other people. And at this point, on behalf of the court and behalf of our community, and I agree, Mr. Trush is right, the court has to look at what's best for our community. I'm not sure that 3 months of doing good things is enough of a record for me to bet the safety of our citizens here in Otsego County on that, or in Roscommon, where the Lions Den is. And when I look at the guidelines, a sentence within the middle of those guidelines is a reasonable sentence. I think it accounts for your past history and your conduct, both previously and in this particular case, the people that you put in danger. And then I think, because I think the court, an argument certainly could be made for a sentence at the high end of the guidelines, given your past record. But I think a sentence in the middle of the guidelines also recognizes the mitigating factors and the fact that you are trying to turn things around and do things differently going forward. So for all those reasons, again, I find that a sentence in the middle of the guidelines is reasonable and accounts for all the factors. So the court is going to, as to the fleeing and eluding charge, the court is going to sentence you to 24 months to 10 years in the Michigan Department of Corrections. You have credit for 26 days served on that charge as to count 2, resisting or obstructing. Again, also 24 months to 4 years in the Michigan Department of Corrections, again with 26 days credit. Those sentences to be served concurrent to each other. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $136 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Trush provide Mr. McKenzie an acknowledgement of those cultures.
Jamie, we were here, just so you know. We were late, sorry. I love you.
Mr. Trush, you ready on Mr. Seguin's case?
Yes, Your Honor.
Mr. Seguin? All right. People versus David Seguin, case number 256845.
Ready to join my contact.
Thank you, Your Honor. Richard Trush on behalf of Mr. Steen.
Date and time set for sentencing in this matter, and Mr. Seguin, have you had an opportunity to go through the pre-sentence report or talk to Mr. Trush about that?
Yes.
Would you need more time to do that before we go forward today? Mr. Trush, are there any additions, deletions, or corrections to that report?
I know Your Honor.
Mr. Hammond signing in. What they did to this computer, but
I think you have to go on the other side and then it wraps around. I'll see if I can get them to change that.
what's that?
I think you've got to go on the other side. Like, are you trying to get it over here?
Yeah, the mouse like
Yeah.
disappears and I can't find it anymore.
Yeah, so go, I think normally you go to the left. I think you have to go to the right and it comes over. I will have them change that for you.
That's fine. Once I know, now that I know, it doesn't matter.
Okay,
Yeah. Thank you.
you're welcome.
Okay. I'm sorry, Mr. Trush, are there any additions, deletions, or corrections to that?
No, Your Honor.
Are there any challenges to the scoring?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
Asked to simply address it on the record. I think it should be done. There's a recognition of jail time held in advance. Normally, the statute has a mandatory 30 days. This is a drug treatment program. I think the court needs to say that in its sentence, so that way we avoid conflicts later on.
Sure, okay. Anything else by way of corrections to the body of the reporter scoring?
No, Judge, the court's well aware there's a situation in this case that should have been successfully complete, delay a sentence. He's going to get a significant benefit. People hope he can do something, right? As opposed to the earlier defendants.
Thank you. Mr. Hamlin, was there anything that you wanted or needed to add to the sentencing in Mr. Seguin's case?
Good morning, Judge. Thank you. Just one real quick thing on his PSI, page 2, specifically number 17.
Yes.
Can you strike, would the court be willing to strike the $30 supervision fee as he is in drug court, and I would suspect he's probably going to be on non-reporting with the state.
Okay, Mr. DeLeo.
We're required to make that recommendation if the court wishes to strike it. That's court's prerogative.
All right, I mean, Mr. Hamlin, I'm aware that there's a supervision fee or participation fee that has to be paid to the drug court, is that right?
That's correct, Your Honor.
Yeah, okay, so in my view, that's sufficient to ensure the proper supervision. So we'll strike paragraph 17. Mr. Hamlin, anything else that you needed to add?
Just that Mr. Seguin has been in the program now for 47 days. He was placed on drug court bond conditions effective September 4th of this year. And I want to ensure that all time while on bond will count towards his time on probation.
I don't know about that. I'm going to impose a probationary term, which typically would start on the date of sentencing. So you guys may look at it differently from the standpoint of his qualification to graduate from the drug court program, but in terms of my sentence, this 24 months of probation would start today.
Got it.
Okay, anything else that you wanted to add, Mr. Hamlin?
No, Your Honor, thank you.
Okay, thank you, Mr. Trush.
Thank you, Your Honor. No additions, corrections, or deletions. Were we moving right into allocution?
We already covered that part,
Okay.
so yes, allocation.
Sorry, I don't do well when things change.
I know, this one has not been disjointed right from the time I clicked the button, so.
In terms of allocution, from the first interaction I had with Mr. Seguin, he has been very open and very dedicated to sobriety. That has been his target from the beginning. It was fortunate for us that we were able to come up with an offer from the prosecutor and his admission to the drug court, which I think are going to make these things, make all of this work for him. Ultimately, if he successfully completes the program, I think it's a huge jumping off point to him to a future sober lifestyle. I think he'll benefit from it. I have every reason to think he's going to complete it. And I think the recommendation here, given all the circumstances, is appropriate. And I sincerely hope that he takes advantage of it because, again, if he does so, as the prosecutor alluded to, there's a big benefit for him at the end in terms of not having that felony on his record.
Okay, thank you, Mr. Seguin. Anything you wanted to say today?
No, Your Honor.
So I did review the report. I'm familiar with what happened in this particular case, as well as your background and your circumstances. I do think that the drug court program is a good resolution of this. I think it gives you the opportunity to really get yourself kind of back on the right track after some slip ups, which at this point in your life, this is the last thing you want to be doing. You want to be enjoying everything that you worked for up till this point and not spend your time having to be involved in the court system. And so I hope that you do take advantage of the program, the tools that you're going to get through that. It's a good program. The people that come out of that program have a really good chance of being successful and moving on. So I hope that you take it seriously and that you follow through with it. And I think it's completely appropriate to give you that opportunity, given your lack of any real serious prior history other than these alcohol-related offenses, which this one technically wasn't, but I think flow from that. So the court is going to place you on probation for a period of 24 months. The main condition of that probation is going to be that you participate in and successfully complete the Otsego County Drug Court program. The court is going to order that you pay any fees associated with that program. As I indicated, the court is not going to order upfront a supervision fee for probation through Department of Corrections. If at any point, though, you are discharged unsuccessfully from the drug court program and you remain on probation at that point, the court would impose a $30 per month supervision fee. But unless and until that happens, there won't be a Department of Corrections supervision fee. court will also adopt all the terms and conditions of probation as listed in this report, many of which are going to be the same as your drug court participation conditions, but some may be different, and your agent will go through those with you. The court is going to order court costs in the amount of $325, attorney fees of $350, an OUID testing fee of $230, a reimbursement, a DNA testing fee of $60, and a $68 state cost. The report indicates that I stated earlier to pay any fees associated with participating in the drug court program, that is $600. You do have the ability to, the court is going to order 6 months in the Otsego County Jail with credit for 2 days served, that time to be held in abeyance, to be served at the discretion either of this court on a violation of the probation or the drug court for a drug court sanction. To the extent that we successfully complete that drug court program pursuant to statute, the court may waive the statutorily required 30 days in jail. Again, you do have the ability to seek an appeal of the sentence. Mr. Trush, have you been able to go through with Mr. Seguin his appellate rights?
Judge, are you ordering the crime victim costs of $130?
Yeah, crime victims assessment of $130 as well.
Your Honor, I'm returning that executed copy to the court.
Okay, and Mr. Hamlin, does Mr. Seguin need any particular instructions for you following this hearing today?
Not today, Your Honor. Thank you.
Okay. All right, thank you, Mr. Seguin. That's all for today. Good luck. to
Thank
going
you,
forward.
Honor.
And Mr. Brown, are you ready with Mr. Proctor's case? House People versus Dustin Proctor. This is file number 256865. We have to respect Mr. Proctor present here in the courtroom today. Counsel for the
Larry Brown on behalf of Mr. Proctor.
This is the date time set for a sentencing hearing in this case. Mr. Proctor had previously been sentenced to participation in the drug court program. He was unsuccessfully discharged from that program and is now before this court for sentencing on his underlying charge. Mr. Proctor, did you have a chance to go through the pre-sentence report and talk to Mr. Brown about that?
Yes, sir.
Mr. Brown, do you have any corrections either to the PSI itself or the update containing the information regarding the drug court participation?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections, Judge.
Any challenges to the scoring?
No, Your Honor, thank you.
Anything on behalf of the people for allocution today?
Yes, Judge. This is a situation where the defendant was given significant benefit in the drug court program. Since that point in time, he miserably failed that program. He had a driving license suspended on May 20th, 2025, a alcohol offense on May 16th, 2025, the July 24th, 2025 and failed to do drug screens on June 18th, which is the report. And there's a recommendation now that perhaps this confuses the people, because I could understand the scenario if the defendant hadn't been given that benefit and then failed it by not doing what he's supposed to. He was sentenced for his possession of meth offense on August 21st, 2025, with 9 felonies. But he was given, and his guidelines at that time were 5 to 28 up to 15 years. He chose again to throw all of that benefit away that he received, taking up a spot in the sobriety court program for somebody who actually perhaps wanted to dedicate themselves to sobriety. I don't think he should get a benefit of that. And it's somewhat confusing that if he successfully completed the program before Howard was in it, but in any case, it's the people's position that this is the time for finally a penalty should be imposed at, but quite frankly, people should have been imposed last time. And I think he should get an MDOC sentence, not simply getting 1 year in jail. Thank you, Your Honor.
Mr. Brown?
Your Honor, Mr. Proctor is here today. He obviously he injured his knee or his ankle, I believe. He is currently employed full-time. He does volunteer at various places as well. I believe he volunteers at a food pantry and helps at the animal shelter. He does have a lot going for him currently. He cares for his grandmother, who really can't care for herself here in Otsego. There were some mess ups, and those were very obvious, and it eventually came down to that kind of a recommendation for being taken out of the drug court. But he is still maintaining his sobriety. He did not go out and get high or get drunk or do something like that with potential of facing incarceration and not being in the drug court anymore. So he is still committed to that and continuing with those. I believe that he chairs some meetings on Tuesdays and Thursdays is what he told me, and he can go into that. And he's got a couple people here to support him. So I would ask the court to take all those things into consideration when fashioning a sentence. He did successfully complete drug court the first time. So there is that potential, and I know he can do this.
Thank you. Mr. Proctor, anything you wanted to say?
I would just like to go with what Larry said. I do chair the NA meetings on Tuesdays and Thursdays. I have Alonzo back there. He's here to confirm. I chair that. The other lady there is my grandma. I take care of her during the day, while the other person we have living there takes care of her at nighttime. And then I am fully employed at Arby's. They're working with me because I am on crutches. Dislocated my left knee and sprained my right ankle. They let me sit in the chair and take orders. I know I messed up by relapsing, but I've gotten sober and stayed sober, and I continue to plan to stay sober. I don't have a want to use anymore. I don't have a want of even that urge. And I'm going to continue with the NA meetings, and once I can actually stand on my feet for longer than 2 hours at a time, I plan on going back to volunteering again.
All right, well, I read through the report. I'm familiar with the circumstances in this case. What brought you before the court in the first place and got you into the drug court program, and then of course your performance during the drug court program and the unsuccessful discharge from that. I've also read through the report, which contains a lot of information about your background, your prior history, and so forth. And I take all of that into consideration along with what the lawyers have had to say here today and what you've had to say. There's a couple of things that really strike me about your case. Number one, your past history, which is extremely negative. 9 prior felonies, 8 prior misdemeanors. You've been on probation 9 times prior. So I don't think, in my view, there's no point in continuing to put you on probation, especially given your unsuccessful discharge from the drug court program. That's some pretty intense supervision if you weren't able to comply with their requirements with as much supervision that you have there. I don't see you being successful on just regular probation. That and you know, we've done it 9 prior times. And at this point, I don't think it's an appropriate use of the court's resources to continue to put you on probation when you're not able to comply with the conditions. So I don't think that's appropriate. You've had 6 prior jail sentences. So between probation, jail, even intense probation like the drug court program, there's been a lot of failures. And in my view, it's time to try something different because everything that we've done in the past has not been successful. I think it's encouraging that you've been able to remain sober since you were discharged from the drug court program. I think it's clear from your past history, you've had periods where you've been able to remain sober. I'm just not convinced that that short term of sobriety has now changed everything and magically going forward, you're not going to use anymore. Your past history suggests that there's a continuing pattern of reoffending. And again, the things that have been tried in the past haven't worked. So I think it's time to try something different. Your guidelines call for a sentence of 5 to 28 months. And I think prison sentence is warranted in this case, given your past record and what's gone on in this particular case. The report indicates that you may be eligible for the boot camp program. I think that might be appropriate. That would allow you to be released from prison much earlier. I think that kind of intervention might be helpful to you, and it's definitely worth the try. So I'm stating it for the record here that I don't have any objection to your participation in the boot camp program through the Department of Corrections. Again, because I think that might help where prior efforts have not. So it is the sentence of the court that you'll be committed to the Michigan Department of Corrections for a period of 24 months to 15 years. Again, I don't have any objection to your participation in the boot camp program. You have credit for 1 day served. Court is required to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Brown, can you provide Mr. Proctor with an acknowledgement of this? All right, please. Yes.
I believe the jail credit is 4 days. There was a few other days he was incarcerated. Looks like there was a bond set.
Okay, thank you for that correction. Credit of 4 days.
You have signed that acknowledgement on tender that to the court.
Good luck to you going forward. Whatever you guys. Okay.
Judge, I'm sorry, was it 24 months to what?
15 years.
Okay, thank you.
Okay, our next hearing set for 10:30.
You can do that now if you'd like.
Okay. Mr. Kibbe,
Oh, not Mr. Kibbe,
Mr. Dofer.
yes.
All right, we'll go on the record in People versus Alex Dofer. This is file number 256895 and 6896.
Larry Brown on behalf of Mr. Dofer.
Mr. Brown, can you tell me the status of these 2 files today?
We had district court, Your Honor, last week. I believe Mr. Dofer's phone was not working, so I could not get a hold of him. He did not appear. Judge Hesseling issued a bench warrant. I did actually, his phone was working a little bit later on, so I called back, left a message. I received an email 22 hours ago from him that he is downstate. His father had a stroke So he is down there taking care of him, and he is not going to be able to be in court today.
Great, thank you, Mr. Rolla.
It's unfortunate he's not here, and I hope Mr. Dover's father does better medically. The people were going to be making an offer today on potential pleas, but without the defendant here, obviously he can't accept it, and we will have to reconsider whether we're going to make it. If the court is provided with some medical information that prevented the defendant from appearing, that's one thing. But at this point in time, and I don't doubt Mr. Brown saying at all, let the record be clear on that. But the situation with family members suddenly having medical issues and then persons not appearing absent the defendant being able to provide that information to the court, I think we have to be looking at a competitive court situation.
Yeah, so number one, I agree. I think Mr. Brown did receive that email. I think the question is whether or not that email is accurate. The court has concerns given that Mr. Dofer failed to appear for district court. There's a bench warrant outstanding for him there. The issues regarding contact between Mr. Brown and Mr. Dofer, and then Mr. Dofer's failure to appear today without providing any kind of documentation. So the court finds that it would be appropriate at this point to request that the people draft a bench warrant. The court will sign that. We'll proceed further with Mr. Dofer's cases once he's arrested and brought before the court.
If there's no objection, we'll have both case numbers on the same bench warrant.
Please, yes.
We'll do so. Thank you, Judge.
And have you had contact with Mr. Kibbe?
I have not.
He's outside.
Oh,
Why don't you talk to him and we'll take a short recess. We'll come back on the record at 10:30.
okay.
Okay, we're on the record in People versus Cody Kibbe, file number 2568884. The record reflect Mr. Kibbe's present here in the courtroom. If I can have counsel put your appearances on.
The record, Your Honor, there's no best people.
Claire Brown on behalf of Mr. Kitty.
Sorry.
Mr. Brown, can you tell me the status of this file today?
Your Honor, I really don't like to do this, but I would request just one more adjournment. I'm still working on some things with Mr. Rolla, and there's some information that I'm probably going to need to have before we really make a final decision on how.
Mr. Rolla?
Judge, people know just to one final 30-day adjournment. The parties are in all the plea agreement. There's one provision of the plea agreement Mr. Brown has to get our office some additional information on so that we can complete that from the defendant's standpoint. And then I would anticipate pleas being entered by the court.
All right. Mr. Kibbe, do you have any objection to going forward that way?
No, Your Honor, I don't.
Okay, so we'll set this for a plea hearing at the mid-November motion day. Mr. Kibbe, between now and then, just make sure that you stay in touch with Mr. Brown. Discuss any plea offers that there are, and I'll just need you to be ready with a decision, a final decision on that next hearing date, okay?
Yes, Your Honor.
That's all for today. Thank you.
Awesome, thank you.
And our next hearing is with People versus Crawford. We can have him brought up, and we'll take a break until Mr. Crawford's present.
All rise, please.
All right, sir, you're Mr. Millsap?
Yes.
Okay.
Good morning, Mike Medaloni on behalf of Mr. Millsap.
Okay, good morning. We're on the record now in People versus Alan Millsap. This is file number 256912. The record should reflect Mr. Millsap's appearing today by video from Department of Corrections. Defense counsel has put his appearance on the record. Mr.
Thank you, Your Honor. For the record, I call on behalf of the people.
Thank you. This is set for a status conference in this case today. Mr. Mataloni, can you tell me where things are at from the defense side?
I think we just need to get a trial date, Judge.
Okay.
I have
right.
I have asked for a polygraph, but my client took one before. So the prosecution has indicated I need to file a motion for that, which leads me to believe that they're not going to give him any consideration, no matter what the polygraph result is. So I don't see any need to waste any time on that.
All right, very good. Mr. Rolla, how many days of trial do you think we would need in this case?
Probably 2 days, Judge, because I'm looking at, I want to say 9 witnesses. As to the polygraph situation, obviously a defendant has a right as a matter of law to have their own private polygraph examination done. But as the defendant has already had a polygraph examination, just because he doesn't agree with the results, doesn't give the reason to have another polygraph. Obviously, I let defense counsel know if they want to bring that matter before the court, and the court should deem it's appropriate that that occur prior to having a trial. Obviously,
with all due respect to Mr. Rolla, I did put into my email why my client wanted a second polygraph, because he lied in the first polygraph that he was not using. He was addicted to crystal meth and was still under the influence of crystal meth at the time that he took the polygraph. But I don't really want to argue about it, to be honest with you, Judge. I mean, if the prosecution is not going to consider the polygraph results, whether private or done by local polygraph examiner, then there's really no point in having a polygraph.
Well, either way, I agree with you, Mr. Mataloni. This is a scheduling conference, so I don't want to argue about that. You guys can file motions to the extent they need to be filed. I just want to get this properly scheduled for trial. I think, I mean, even with 9 witnesses in the jury selection process, it might be safer to set aside 3 days. Do you have any objection to that?
Not at all, Judge. Again,
Mr. Mataloni, do you think 3 days is enough for trial?
Sure.
Okay. And Mr. Mataloni, I'm assuming you're requesting a jury trial?
Yes, sir.
Okay. Mr. Rolla, how much time do you need to be prepared for the court to set the trial dates in this case?
no less than 60 days, maybe 90 days, Judge.
Mr. Mataloni, if we set this for 90 days out, is that enough time for you, or did you want to request a different time set interval?
I only know that I have a couple murder trials in December, and I think one in January, and then I have one starting February 3rd. So I'm not opposed to a March trial date.
Okay, Mr. Rolla, do you have any objection to that?
Not at all, thank you.
Okay, so we'll set it for a 3-day jury trial, March of 2026. And the court will set up those trial dates. The court will set this for a final status conference about 30 days prior to the trial date. That will be the motion cutoff. So either side's free to file motions at any time, but they would have to be filed and heard no later than the date of that final status conference. That would also be the plea cutoff. So to the extent that there are any plea discussions or negotiations, that final status conference would be the last date to enter into a plea. The court will send out a scheduling order with these dates that we've discussed here today, along with the trial dates and the date of the final status conference. Mr. Mataloni, are there any other dates that you would like to request in terms of scheduling here today?
I don't think so. I don't think we need anything else.
Okay, Mr. Rowland.
Nothing in that regard, Judge, but as we are beyond the 180-day time period, the record should reflect that the last adjournment was requested at the point at the request of defense.
No argument there. And then, the record should reflect my client's serving a prison sentence, and he's not due to be released this year or next year, my understanding is so. And if it is next year, it's at the end of the year, so there's no prejudice to the defendant.
Very good. And in light of the time period that we have before we can have a trial, if the defense still wants it done, I will put in a request to the polygraph examiner to see if they'll have another examination of it.
I'm only interested in the polygraph, Mr. Rolla, if you're going to give any consideration for the results. If you're not, then I don't see spending anybody's money for nothing.
I always consider it.
All right, I'm gonna let you guys discuss this amongst
Very good,
yourselves. I
Judge.
don't need to hear any of this, so.
Okay, thank you, Judge. Sorry about
No, that's all right. Mr. Manaloni, anything else I can address for your side today?
that. No, sir. You know us lawyers, Judge, we like to talk too much.
And that's okay. I totally get it. I do too, but we just don't have to do it on the record.
Very good, Judge. Thank you.
All right,
Thanks, Mike. Thank you, everyone.
we'll disconnect at this time.
All right, thank you.
Dion, that get moved.
I think I do still have him on. I do.
All right, I'm gonna call People versus Brentley Michael Dion. This is file number 256861. Mr. Dion is not present. This matter was set for hearing at 11:15. It's now 11:23. I don't see Mr. Dion or. Oh, hold on a second. I might have some more information here. Jen. Hearing was adjourned this morning, so we don't have to address that. That concludes our morning docket. Quarterly recess until 1:30.
Thank you.
All rise.